Yes.
Yes.
Yes, yes.
My lord, the challenge has been made
Hmm.
under section for seeking quashing of the proceeding initiated by GST authority and subsequent arrest of made by the GST authority, which is, my lord, in contravention of section 69.
Already arrested.
Already arrested. I am seeking
When?
he was arrested on 10.
10th.
10. So I am seeking release of that. I will place, my lord. Coordinate bench of this honorable court also passed order. A number of orders have been passed on the same facts.
Okay.
I can say that the matter is covered by the
Covered.
decision. So also, I have prepared one compilation. Before that, my lord, I would like to place facts of the matter, your lordship. My lord, may I kindly come to page 58. It is the complaint filed by Annexer 1, 58A. And I am telling you also to kindly see para number 2. It is the complaint filed by GST authority before learned trial court, my lord.
Okay.
That the accused so and so, his director, my lord, so and so was arrested on 10/1/2026 at about 2:30 p.m.
Where are you reading? Page?
Page 58,
58.
capital A.
Okay.
Capital A. Bottom, my lord, para number 2.
Para 2. Is that the accused?
That the accused, Sri so and so, age about so and so, address, it is written, my lord, Assam was arrested on 10/1/2026 at about 2:30 p.m. by the officers of Central Goods and Service Tax Commissioner, Dimapur, Nagaland, for committing offence punishable under section so and so of GST relating to issuing and using the fake GST invoice without actual supply. This is very important. Without actual supply or receipt of the underlying goods, causing wrongful passing of input tax credit amounting to rupees so and so and so and so. Now, as per their own circular, your lordship, if my lord, supply has not been made, then the question of levy doesn't arise. If the question of levy doesn't arise, there is no question of, my lord, evasion of tax, my lord, because section 132 says, my lord, evaded, tax evaded, unless and until tax has not been determined, because the determination of tax can only be done by, my lord, assessing authority. My lord, vigilance has no power to determine, assess, my lord, to act as an assessing authority. It is the assessing authority who will determine, my lord, liability of to pay tax. It is not the vigilance who will decide, number 1. Number 2, this is on merit, your lordship, because I have filed criminal petition seeking quashing of entire proceeding. For interim, today I am insisting for interim, my lord. For interim, your lordship, I am praying for release on the ground, my lord. That when I was asked to appear, I appeared. My lord, no notice under section 41, capital A. Now it is, my lord, 35 within bracket 3 has been served upon the petitioner, my lord. My lord, Ernest Kumar says, my lord, it is mandatory. And Satyendra until says, my lord, if notice under section 41A has not been served, then in that case, my lord, I am entitled for bail. That was taken into consideration by coordinate bench of this honorable court. My lord,
section 35(3).
35 bracket 3 of BNS. Earlier it was, my lord, 41.
Earlier 41, yes.
My lord, section 69, which empowers my section 69.
Okay.
Section 69, my lord, of, my lord, GST Act, my lord, which empowers the authority to arrest in case, my lord, evasion is, my lord, above 5 crore. If it is, my lord, up to 5 crore or less than 5 crore, your lordship, my lord, it is bailable. But if it is, my lord, above 5 crore, then it is none.
Do we have CGST Act?
Yes, I have. It is there, my lord. I will place, my lord.
It's here in the compilation.
No, not compilation. It is Act.
Oh, okay.
Compilation, I will place, my lord, squarely covered decision, man. Interim bail was granted by this honorable court in Varun Goyal case. It was filed under section. I will place, my lord, section 132 and 69.
Okay.
My lord, 69 further says, my lord, that if the commissioner has reason to believe then he will authorize to the person to arrest.
Hmm.
So the ingredient is, my lord, precondition is there has to be, my lord, reason to believe.
Hmm.
And the copy of this honorable court held, my lord, copy of reason to believe is required to be furnished to the accused against whom the proceeding has been initiated or who has been arrested. In the present case, that has not been done. On that score, this honorable court held that arrest is illegal. Second, my lord,
Yes.
apex court says, my lord, in Arnav Goswami case, that also I place, that the person, if he has not been arrested in accordance with law, keeping him behind 1 day is not permissible. That was also taken note by this honorable court, my lord. So now I am taking your lordship to first act, then I will come to compilation. GST Act, my lord, can you come to section 69 first? It empowers the to arrest, power to arrest. I think it is based on 64.
Section 69.
69.
Yes.
Madam, may I read your lordship? Where the commissioner has reasons to believe that a person has committed any offence specified in clause A or clause B or clause C or clause D of subsection 1 of section 132, which is punishable under clause 1 or 2 or subsection 1 or subsection 2 of this said section, he may order, authorize any person of central tax to arrest such person. To form opinion for arresting me, as per section 69, my lord.
Acha, 1 minute, Learned Counsel. This is a criminal petition. Okay. So, since you're already arrested, don't you have to file a bail application?
This honorable court in criminal petition granted bail, interim bail. On the basis of the judgment given by Arnav Goswami case, apex court, my lord, can you come to compilation first?
Okay.
It will be easier. Page 1 of my compilation. Page 1.
Yes.
And at the top, you will see criminal petition number 692.
699.
My lord, criminal petition was filed. Now, my lord, kindly come to page 2, next page, para number 2. The present application has been filed under section so and so, for setting aside or passing the complaint dated so and so, grounds of arrest dated so and so, authorization to arrest dated so and so, order dated so and so, and the proceedings initiated against the petitioner under section so and so, along with a prayer to release the accused so and so on bail who has been in custody since itna, which is in violation of the provision of so and so. Now, my lord, can you come to? This is the order passed during in interim, my lord. It is an interim. Page 14.
Page 14.
1-4, my lord. Para 21. May I read you, okay? 21. Before delving into the merits of the matter or rendering any conclusive finding thereon, it is pertinent to note that certain submissions have been recorded on behalf of the petitioner touching upon the merits of the present petition. However, at this stage, I consider it appropriate to restrict the scope of the present order solely to the prayer for bail as made by the petitioner. It is also noted that the learned counsel for the state respondent has sought time to file detailed objection, written objection on merit of the complaint. Thereupon, it is the admitted fact that respondent suit issued authorization of arrest of the petitioner to the respondent suit on prejudice of the grounds of arrest. It appears that certain reasons have been assigned for effecting the arrest, but it cannot be denied that there was no proper compliance of section 41A of CRPC corresponding to 35(3) BNSS, which are mandatorily required to be followed. From the view expressed by Honorable Apex Court in the case of Radhika Agrawal, that I have annexed, my lord, it is evident that though the GST is special enactment, but the same cannot be considered as a complete code in itself as regard to the provisions of search, seizure, and arrest. And as stated above, the provisions of Code of Criminal Procedure would be applicable unless it is expressly or impliedly barred by the provisions of this said act. But here in the instant case, it is seen that there is no compliance of section 40, 41 of CRPC corresponding to so and so, which is mandatorily required to be followed as per the guidelines of Honorable Supreme Court. In the cases of Agnes Kumar versus State of Bihar and reiterated in Satyendra and Kumar Andy versus CBI. Thereafter, my lord, it is also an admitted position that though the grounds of arrest were communicated to the petitioner, but there is no communication of reason to believe, which ought to have been recorded before issuing authorization letter of arrest. As held by Honorable Supreme Court in the case of Radhika Agrawal, the requirement of furnishing the reasons to believe to the arrestee is not a mere formality, but a substantive safeguard enabling the person concerned to challenge the legality of arrest in accordance with law. But here in the instant case, though it is stated that the reasons of belief were duly recorded by the competent authority prior to issuance of authorization to arrest, but there is nothing on record to show that the same were communicated to the petitioner either at the time of arrest or along with the grounds of arrest. Such non-communication of foundational reasons vitiates the process and undermines the safeguard granted under law, render the arrest procedurally infirm. And thereafter, my lord, this honorable court, after taking place para 25, interim bail, it was granted. According to this court, find it to fit case to extend the benefit of interim bail, like in the present case, to the accused petitioner till the disposal of the present criminal petition. Thereafter, my lord, a number of decisions, similar type of orders have been passed by Honorable Gauhati. This is one of another decision in Network Journal. It was passed interim order in writ petition, my lord.
So you're saying that in this petition also similar circumstances.
Exactly.
No notice under 41A was given before the arrest.
No reason to believe has been committed. So, my lord, being my lord, it's clear cut violation of my lord section 69 and section 132. So matter is squarely covered by my Varun Goel order, part by this honorable court. I have been placed in a similar situation, my lord, so similar order can be passed. This is my humble submission. And this order was passed.
Annexure 3 is the ground of arrest.
Next
Arrest. Non-cooperative and result.
Ground of arrest. They have written there.
From GST.
And my lord, authorization to arrest is, my lord, page 66, annexure 4. Here they are saying reasonable ground. But what is the ground? They are not saying. All the entire records have been annexed with this petition. I have taken certified copy entire records and everything has been annexed, your lordship. And the judgments which was regarding in Varun Goel, that all the judgments I have annexed with my comments.
Let's see this Radhika Agrawal.
Radhika Agrawal, page 30. In fact, it was quoted by Gandhi. 30. Start from 30.
Just take us to the operative portion.
Thanks. My lord,
Page,
my lord, para 71. Para 71, my lord, say would be
page 72.
page 72, man. The petitioners contend that section so and so of GST Act permits compounding of offence and therefore the ratio of weight might be shown applied to the GST Act. The decision of so and so could also observe itself carves out an exception when an assessment order under the Finance Act may not be required. Namely, cases where a person who is shown to be a habitual evader as one who has not filed service tax returns for continuous period of time. This is not my case. Who has a history of repeated defaults for which there have been a fines, penalties imposed. There also may slip over. It is my lord may kindly come to thereafter petitioner further submitted that till an assessment order of passed under section so and so, the liability cannot be quantified and hence an SSC cannot move an application for compounding of offence. We would reject the said submission because there is a difference between compounding of offence, it is for compounding, and the arrest of a person. For arrest is different. We have already stipulated sufficient safeguard to ensure that no arrests are made till the commissioner is able to show and establish on the basis of material and evidence that the conditions of clause so and so, so and so, and so and so are satisfied and therefore offences are nonetheless. There has to be material, there has to be my reason to believe. It has not been provided. Commissioner state way authorizes my law that
reason to believe was not provided.
not provided. And in Varun Goel, you also has seen it is mandatorily required. Not providing make the entire arrest my law infirm. Next also, my lord, the same question again came up before Honorable Gauhati High Court, my lord. And you will also may kindly see page 18.
Page 18 of
1A
the
of compilation, my lord.
compilation. Yes.
My lord, here you will see it was writ petition was filed, my lord. At the top, my lord, writ petition number so and so. So 226 or my lord 482 as held in Arnab Goswami case. And my lord, after hearing page 26.
Here also interim prayer was there.
Yes, ma'am. Page 26, para 30.
Okay.
Accordingly, the petition is directed to be released on interim bail, subject to furnishing personal bond of so and so. So my submission is, my lord. Let my lord, it is everything is documentary, my lord. Everything has been seized. I am in judicial custody, and there prima facie, my lord, there is a violation, my lord, of 41A not providing 41A notice. Reason to believe, my lord. Determination of tax has not been done, my lord. So far as my lord, final argument is concerned, let them file affidavit whether for quashing of
Yes. That is a different issue. We are now on the interim. Because regarding the main case, obviously notice will be issued.
I am on interim, my lord. So first day, my lord, this one will granted interim in others case.
Where is your synopsis?
Synopsis of my lord petition.
Yes.
Synopsis, I think, my lord, that inadvertently it was, my lord, it escaped, my lord. It is my mistake, my lord.
Oh.
If my lord, but facts I will place, my lord. You are also
No, it's easier for the court when there is a synopsis.
If you are also required, I think by 1 o'clock I will provide, my lord.
Because even the necessary orders, while passing the necessary orders, it's very helpful. Anyway, anyone to accept notice, you are accepting for which one? One.
All the respondents.
All respondents. Okay. Right. Heard Learned Counsel for the petitioner, Mr.
A. Goel.
A. Goel. Stop. The present application under Section 528 of the BNSS has been filed, praying for setting aside and quashing the complaint dated 10/1/2026, the arrest memo dated 10/1/2026, grounds of arrest dated 10/1/2026, authorization to arrest dated 10/1/2026, order dated 11/6/2025, passed by the learned Chief Judicial Magistrate Dimapur in case number 01/CGST/DMR/2025-26, corresponding to GR number 16/2026 and the proceedings initiated against the petitioner under Section 132, Clause 1, Clause B, small b, and Section 132, Clause 1, Clause C of the Central Goods and Services Tax Act 2017, and also the subsequent arrest of the petitioner, Shri such and such, who has been in custody since 10/1/2026. Stop. Para. The main contention of the petitioner herein is that the proceedings against the petitioner, White case number such and such, the earlier one, okay, 01/, registered under Section 132, Clause 5 of the CGST Act, and subsequent arrest of the petitioner is in violation of the provisions of the CGST Act 2017 and the law laid down therein. Stop. It is further submitted that the respondents have resorted to arrest of the petitioner without conducting any assessment proceeding and without providing copy of reason to believe and necessity of arrest. Stop. It is further submitted that the provisions of Section 35, Clause 3 of the BNSS / Section 41A of the CRPC has not been complied with by the respondents before the arrest of the petitioner. Stop. The petitioner has relied upon the order dated 25/6/2025 issued in criminal petition 699/2025, wherein a coordinate bench of this court has entertained a similar petition in respect of. This is also regarding GST.
GST, same one. Only amount is different.
In respect of in respect of proceedings under the GST Act, GNST Act 2017. Stop. In the aforementioned case, the coordinate bench had entertained the criminal petition and had entertained the criminal petition, issued notice, and had granted interim bail to the petitioner pending disposal of the criminal petition due to violation of the provisions of law.
Para 22 and 23.
Yes. The coordinate bench had held that there was no communication of reasons to believe which ought to have been recorded before issuing the authorization letter of arrest. The coordinate bench had also relied on the judgment of the Honorable Supreme Court in the case of Radhika Agarwal. The citation.
Citation 2025.
Radhika Agarwal in versus Union of India,
2025.
reported in 2025 SCC